matter of Moulsdale, trading as Moulsdale Properties, against Commissioners for His Majesty's Revenue and Customs.
Lady Rose will explain the Court's judgment.
This appeal concerns whether Mr Moulsdale, the appellant, should have charged value-added tax, VAT, on the sale price of a property which he sold to a purchaser who had no connection to him in September 2014. The point of law it raises is the correct construction of tax legislation that deals with supplies of land. Sales of land and buildings are generally exempt from VAT in accordance with Schedule 9 Group 1 to the Value Added Tax 1994, which I will refer to as the VAT Act. However, paragraph 1 of Schedule 10 to the VAT Act gives a taxable person an option to tax transactions relating to a particular parcel of land. Where that option to tax is exercised, VAT must be charged and accounted for to HMRC whenever there is a sale of that land. Paragraphs 12 to 17 of Schedule 10 to the VAT Act provide for compulsory disapplication of an option to tax in certain circumstances. If the option to tax is disapplied in accordance with those paragraphs, a sale of property where an option to tax has been exercised goes back to being a sale that is VAT exempt. In 2001, Mr Moulsdale bought a building for a purchase price to which VAT was added because the seller had opted to tax the land on which the building was built. Mr Moulsdale then himself exercised an option to tax that land. This enabled him to claim back from HMRC the input VAT he had paid to the seller. Years later, in 2014, Mr Moulsdale sold the property to a company which was not registered for VAT. When Mr Moulsdale sold the property, he did not add VAT to the purchase price. He argues that he did not charge VAT because Schedule 10 to the VAT Act meant that his option to tax was disapplied, and so the sale of the property was VAT exempt. The respondent, HMRC, disagreed. HMRC's position is that the sale was not tax exempt, and Mr Moulsdale should have charged the purchaser VAT and then paid that VAT over to HMRC. Mr Moulsdale challenged HMRC's decision was unsuccessful before the first-tier tribunal, and then on appeal to the upper tribunal, and then to the inner house of the Court of Session in Scotland. Mr Moulsdale now appeals to the Supreme Court. The Supreme Court unanimously dismisses the appeal. Schedule 10 to the VAT Act is the legislation which determines whether VAT is chargeable on the sale of land. This case turns on whether Mr Moulsdale is a developer of the land as defined in paragraphs 12 to 17 of that schedule. Unfortunately, because of the way the provisions are drafted, there is a conundrum in the legislation when it comes to deciding whether Mr Moulsdale is a developer of the land, and hence whether the sale of the land is subject to VAT or is exempt from VAT. Under Schedule 10, if Mr Moulsdale did intend or expect the purchaser to pay him VAT on the sale price of the land, that price being more than a minimum set, then Mr Moulsdale is a developer of the land. But that would mean that paragraph 12.1 of the Schedule 10 disapplies the option to tax so that the sale of the land goes back to being an exempt transaction on which Mr Moulsdale should not charge VAT. However, if Mr Moulsdale did not intend or expect that the purchaser would pay him VAT on the price of the land, then Mr Moulsdale would not fall within the definition of a developer of the land, and the option to tax would still apply, making the sale subject to VAT. So the effect of the relevant Schedule 10 provision seems to be, therefore, that if Mr Moulsdale charges VAT, then he is a developer of the land and VAT is not payable. But if Mr Moulsdale does not charge VAT, then he is not a developer of the land, and the option to tax still applies to the land, so that he should charge VAT. Drafting tax legislation is a difficult and complicated task, so it's perhaps not surprising that sometimes the legislation does not quite work. and Mr Moulsdale and HMRC both accept that this circularity problem created by the provisions of Schedule 10 is such an instance, but they have proposed different solutions. Mr Moulsdale argues for a broad construction of the provisions. He contends that because he has exercised the option to tax in relation to the land, he did intend or expect that the purchaser would pay VAT on the purchase price of the property. According to Mr Moulsdale's solution, the VAT inquiry would stop there. Accordingly, because he had the relevant intention and expectation, he is a developer of the land and the sale is therefore exempt, which would mean he was correct not to charge VAT. So Mr Moulsdale argues that to avoid the circularity, one should not then go on to reconsider the disapplication of option to tax after concluding the sale is exempt. However, the Supreme Court holds that the narrower construction, which was put forward by HMRC, is the correct construction, as it makes as much sense as one can of the legislation. HMRC's argument, which the Court accepts, is that when applying these provisions, in order to decide whether the sale should bear VAT or not, the relevant intention or expectation as to whether the purchaser would pay VAT on the capital item in relation to the land must be an intention or expectation about incurring VAT on some other cost, a cost different from the actual price of the land or the building itself. Thus, the Court holds HMRC was correct that Mr Moulsdale should have charged VAT on the sale price. The Supreme Court relies on the purpose behind Schedule 10, being that it is aimed at ensuring that exempt businesses cannot recover input VAT. This purpose would be defeated on the construction Mr Moulsdale argues for. On his broad construction, the provisions would enable him to have the benefit of the option to tax the land as long as that was favourable to him, but then he could switch off the option to tax simply by selling it if he did not want to have to charge the purchaser VAT on the purchase price. The Supreme Court then, therefore, unanimously dismisses Mr Moulsdale's appeal.
The Court is now adjourned.